In the Shoes of the Original Creditor and Other Essential Lies of Debt Collectors. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. Debt collectors often claim that they stand in the shoes of the original creditor. They do this as part of an attempt, illegal in my opinion, to intimidate the people they're harassing into believing they have more information than they do. That may work on some people, but not on you. You should make them pay if they try it on you. There are various ways the in the shoes argument comes up, often beginning with the petition in which the debt collector, a company you may never have heard of, claims that it extended credit to you, it sought repayment, and it was refused payment. You know it never happened that way if you think about it at all, but that's the point. They're trying to keep you from thinking about it at all. What typically happens is that some debt collector bought the debt from somebody claiming you owed them money. As part of that purchase, they may have obtained a few electronic copies of documents and a computer record claiming you owe the money. This isn't nearly enough to prove that you really owe them the money, and they want you to think that they have all the records because they lent you the money. Or they want to imply some sort of moral claim to the money in your mind. The claim that they're the ones who lent you the money adds nothing legally, and it serves no legal purpose. They'll often take it another step and actually submit affidavits claiming that you borrowed money from them. Only they say plaintiff rather than their name, since that would show the trick if they put their name in. Or they'll send you requests for admissions asking you to admit borrowing money from them. Again, they say plaintiff to hide the fact that they're asking you to admit you borrowed money directly from them when you never did. And they know you didn't. This is outright deceit, and it ought to offend anyone's sense of fair play. But debt collectors don't have a sense of fair play. When you claim, rightly in my opinion, that this is an unfair debt collection practice under the Fair Debt Collection Practices Act, the FDCPA, the debt collector argues vehemently that it has a right to say these things because when it bought the debt, it stepped into the shoes of the original creditor. Nonsense. The grain of truth behind the debt collector's deception is that a company collecting another's debt generally has all the same rights to collect the money as the original creditor did. Debts are transferable in most cases, in other words, and the person assigned the debt has the same right to collect as the person who transferred the debt. But debt collectors do not become the original creditor in any sense. Their buying the debt, after all, is what made them a debt collector. And claiming to be the original creditor is patently deceptive. Under the Fair Debt Collection Practices Act, a person, including companies that routinely buy debts, for the purposes of collecting on them, is considered a debt collector. Essentially, all the provisions of the FDCPA apply to debt collectors, and foremost among these are the provisions against deceptive or unfair debt collection practices. These provisions apply to debt collectors, but in general do not apply to original creditors. Thus, the debt collector's claim to stand in the shoes of the original creditor is, regarding their collection efforts, absolutely untrue. If they try this on you, maybe you can make them pay. As I mentioned above, the debt collectors often send you discovery materials, i.e., requests for admissions, interrogatories, requests for documents, which use the word plaintiff instead of the company that you theoretically borrowed the money from. What would prevent you from reading the word literally? They ask you to admit borrowing money from them, and you know you never did that. Or they ask you for all the documents reflecting your account with them, and you know you never had an account with them. Why not simply deny it? That would be the literal truth. And in the legal process, you are held to the literal truth. As I've argued above, the claim that the debts were originally owed to the debt collector are false and deceptive. If you are looking for a counterclaim, and I have often pointed out that counterclaims can give you important power in a lawsuit by a debt collector, you might consider this an opportunity to make a counterclaim. You might consider this tactic, regardless of where it comes up in the litigation, as an unfair debt collection practice. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forms, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.